At the White House this evening, President Trump signed his multi-trillion-dollar tax cut and spending plan he calls One Big Beautiful Bill.
On July 4th, 2025, something huge changed in U.S. immigration law. For the first time ever, applying for asylum now costs money. $100 just to file the application and another $100 every year while the case is pending. And that's only the beginning. The law behind these changes is called H.R. 1, also known as OBBA, which is short for the One Big Beautiful Bill. And whether you're working on asylum, TPS, parole, or court filings, this law is going to affect your work starting now. In this video, I'm going to walk you through the most important changes from rising fees to shrinking waivers, and what they mean for your day-to-day work as a legal professional. No politics, no hype, just the facts and what to do about them. And asylum was not the only form that saw a big increase in fees. Work permits, TPS applications, parole requests, cancellation of removal, even motions to reopen are now way more expensive to file. And the fees, well, they didn't just go up a little bit, they skyrocketed. So let's break it down category by category, starting with work permits. Before the new law, the filing fee for a work permit varied depending on the applicant's category. So for example, individuals applying for work authorization based on asylum were not required to pay any fee either for the initial application or for renewals. Under the new law though, certain categories face a standardized fee. Specifically, applicants filing for a work permit based on asylum, TPS, or parole must now pay $550 for the initial application and $275 for each renewal. The law does not explicitly impose this fee on every I-765 category, so it is important to check the current USCIS fee schedule based on the specific eligibility category that's going to be used in the application. For individuals applying for Temporary Protected Status or TPS, the new law introduced a significant change. Previously, TPS applicants paid between $30 and $50 for their initial application. Now, there's a mandatory $500 filing fee for the TPS application. That does not include the cost of a work permit, which most TPS recipients also need. So in most cases, applicants will be paying $500 for TPS plus $550 for the work permit and $275 for each renewal. H.R. 1 also introduced major fees for individuals seeking immigration parole, including those applying for humanitarian parole or family reunification-based parole programs. Previously, there was no formal filing fee for most parole requests. Now, the filing fee to request parole has been set at $1,000. And if the applicant wants to request work authorization, which is very common, that adds $550 for the initial application and $275 for each renewal. The application fee for cancellation of removal has also changed dramatically. Previously, whether the applicant was a lawful permanent resident or not, the total cost, including the biometrics fee, was typically under $200. Now, under the new law, the fee for certain non-permanent residents has been increased to, wait for it, $1,500. And for lawful permanent residents, the new fee is $600. Another important change affects minors applying for immigration benefits under the Special Immigrant Juvenile or SIJ category. Previously, SIJ applicants were not required to pay a fee in connection with their I-360 applications. Under the new law, a new $250 filing fee has been introduced specifically for SIJ petitions. The cost of challenging a decision in immigration court has also increased a lot. Before the new law, the filing fee for an appeal before the BIA was $110. Filing a motion to reopen or motion to reconsider also came with relatively low costs, and some categories allowed for fee waivers, particularly for motions connected to an asylum request or in cases of in absentia removal order. Now, under the new law, the filing fee for both BIA appeals and motions to reopen or reconsider has been increased to $900. These fee increases aren't just about money. They come with real risks that can affect the outcome of a case. And one of the biggest risks is getting the fee wrong. If the wrong fee is submitted or if a waiver is requested where waivers are no longer allowed, the application or motion can be rejected outright. That means it doesn't get filed. And in many cases, there's no extension and no second chance. A rejected filing can cause someone to miss a critical deadline, whether it's to apply for asylum, to file a motion to reopen, or to appeal a judge's decision. And once a deadline is missed, the consequences can be quite serious. The client could be issued a final removal order, lose eligibility for relief, or even be deported without a chance to argue their case. Another important thing, these fees are non-refundable. If a filing is rejected because the payment was incorrect or incomplete, the government won't give that money back. These changes also mean that immigration legal teams, especially paralegals, must be more precise than ever. Even if you didn't before, from now on, make sure the correct fee is attached, the form is the latest edition, and every signature and supporting document is included, because a small mistake now carries a much bigger cost, both financially and legally. Now let's talk about fee waivers, because this part of the new law has quietly made things a lot harder for low-income immigrants. Under the new rules, most USCIS filings that used to qualify for fee waivers no longer do. And that includes asylum applications, TPS, parole, and even EADs tied to those categories. Across the board, these are now full fee filings. As for filings in immigration court, some still allow fee waivers so long as the person can show financial hardship or an exception under the law. So, motions to reopen or reconsider, adjustment of status, cancellation of removal, and appeals to the BIA may still have their fees waived under certain circumstances. So, while fee waivers haven't entirely disappeared, they're now much more limited and mostly tied to hardship in the context of court. Now, I've included in the description a document from AILA with a full table showing which forms still qualify for waivers and which don't. It's a helpful reference to keep on hand as you navigate these changes. So yeah, as you guys can see, a lot of immigration forms are now way more expensive. Immigration court, definitely more complicated. And on top of that, DHS just got a big boost in funding, and so did UIR. So we can probably expect more enforcement and faster enforcement across the board. That means it's time to tighten up your systems and review your checklists, update your intake scripts, and always make sure you got the correct filing fees before sending anything out. Now, more than ever, we can't afford to make mistakes, and that's exactly why I made a separate video walking through the top 10 mistakes immigration paralegals make in court preparation and how to avoid them. Definitely check that one out if you haven't yet. And I'm curious, what do you think about these changes? Have they already affected your work, or do you think it's just going to be business as usual? If this video helped you in any way, please leave a like, share it, and subscribe to the channel. It helps more people find the content, and it helps me keep making it for you. Thanks for watching, and as always, keep your steps steady and your purpose clear. I'll see you in the next one.